Alright everybody, so how we doing today? Alright, so from Reason Magazine, Free Minds and Free Markets, Lindsey Graham's dishonest defense of red flag laws. The Second Amendment is not a suicide pact, the senator says while glossing over the due process issues raised by gun confiscation orders. Well, of course he glosses over them. He's probably biased in favor of this sort of thing. Now mind you, there's no such thing as someone being truly quote-unquote unbiased. Everyone has their biases, but biases can be ignored. Biases can be overridden by a sense of, well, deciding what's fair. Like, for instance, this show, the name of the show is The Unglobalist. That's what I call it. I am against globalism. I think globalism is a bad thing. It's a very bad thing. However, when a globalist organization like the EU or the UN does something right, I'm going to admit it. I'm going to be the bigger man and I'm going to admit it. When they do something wrong, I'm going to call them out on it. That's called being fair. Is Lindsey Graham being fair? Let's see. Senator Lindsey Graham, who plans to introduce a bill that would provide grants to encourage the passive enforcement of so-called red flag laws, recently defended such statutes against the complaint that they suspend people's Second Amendment rights without due process. His argument's more than a little misleading. There are plenty of judicial proceedings every day in America where somebody is adjudged to be a danger to themselves and others, and they're put into a mental health facility, Graham told Fox News anchor Martha McCallum. That goes on all the time, so that process would apply to gun ownership. We have judicial hearings all over America every day dealing with people who become a danger to themselves and others, and this is just an extension of that concept. Graham did not mention that the standards for involuntary psychiatric treatment are notably stricter than the standards for taking away people's guns under red flag laws. Under Florida's Baker Act, for example, the state has to show by clear and convincing evidence a substantial likelihood that a candidate for commitment because of mental illness will in the near future inflict serious bodily harm on self or others, as evidenced by recent behavior causing, attempting, or threatening such harm. Well, that seems like a prudent measure. Keep in mind that such deliberations are so frequently very arbitrary based on certain standards that, while agreed upon, are still in some sense a matter of arbitration. So, basing such arbitrary standards, or rather using such arbitrary standards for the basis of taking away people's guns and gun rights, yeah, I just don't see anything good coming from this. I just don't see anything good coming out of this. Florida's red flag law, by contrast, authorizes a judge to issue a final gun confiscation order, which lasts up to a year and can be extended. When there is clear and convincing evidence that the respondent poses a significant danger of causing personal injury to himself or herself or others. No psychiatric diagnosis is required. Significant danger is undefined. The purported threat need not be imminent, and the judge may consider any relevant evidence. Those permissive standards help explain why Florida judges issue final risk protection orders 95% of the time. Nobody's going to lose their gun unless they have their day in court. Graham assured McCallum that is simply not true. All 17 states with red flag laws in the District of Columbia allows judges to issue preliminary gun confiscation orders without giving the respondent a chance to rebut against him. The maximum length of such ex parte orders ranges from a week in Nevada to 6 months for good cause. In Maryland, 14 days is the most common limit. Those limits are not necessarily followed in practice, while Indiana nationally requires that a hearing be held within 14 days of a gun seizure. A 2015 study found that gun owners waited an average of more than 9 months before a court decided whether police could keep their firearms. I don't know why, but for some reason when I read out the words gun seizure, I thought of something else other than gun confiscation. I thought of a seizure while holding a gun, or maybe a seizure caused by the sight of a gun. Yeah, maybe that's my diseased brain and my weird, twisted sense of humor coming to the forefront. But you know how the government is with this sort of thing. The hearing should ideally be held within 14 days, but you'd be damn sure that they're going to find a way to make sure that the waiting period is even longer than that. This is the United States government we're talking about here. They're notorious for excess bureaucracy, red tape, and of course, everyone's favorite thing, procrastination. In some states, the standard for ex parte orders is minimal. New York requires probable cause to believe the respondent is likely to cause serious harm to himself or others. Other states are stricter. Vermont requires showing by a preponderance of the evidence that the respondent poses an immediate extreme risk. The experience in Florida and Maryland suggests that judges almost always agree to issue ex parte orders. An honest defense of red flag laws would grapple with these issues. But Graham prefers to pretend they do not exist, dismissing critics of red flag laws as libertarians, he told McCallum. The Second Amendment is not a suicide pact, which is the sort of thing politicians say when they find constitutional rights inconvenient. So he's dismissing his critics by calling them libertarians. That's not exactly an insult from where I'm standing, Mr. Graham. That's actually probably the greatest compliment you could ever give to anyone at this point. I am not even kidding right now. I am entirely serious. But yeah, Lindsey Graham fails to defend his position concerning these red flag laws. And quite frankly, I don't see anyone else even remotely being able to succeed. They're all going to fail on some level. They're all going to try to dismiss how this is a violation of Second Amendment rights or other sort of violation or a method of oppression. They're all going to try to find some way to deny it, and they're all going to fail. So I say it's important to call them out on it when they do. It's important to note and make it clear that we noticed you could not defend your position because your position is untenable. It cannot be defended. This is unconstitutional and therefore illegal. But you know, that's never stopped politicians before making illegal laws. Of course not. They get away with it all the time. Trump talks about draining the swamp of that sort of crap, and then he goes and engages in it himself. I know I'll get deranked for saying this exact phrase, but Trump's a jackass. I, you, we, anyone who voted for Trump, we voted for a jackass. Makes you feel real good, don't it? I sooner should have voted for friggin' Steve-O than voting for Trump. I don't even like Jackass. I think it's so stupid as hell. But I should have voted for any of them before I voted for friggin' Trump. I made a mistake. But hey, at least I'm a big enough man I can own up to it. But let's just talk about this. Like, the best he could come up with is that there are plenty of judicial proceedings every day in America where somebody is adjudged to be a danger to themselves and others and they're put into a mental health facility. Yeah. But how does that explain why a violation of someone's Second Amendment rights can seemingly be okay? Maybe some of those proceedings are illegal, immoral, and unethical as well. Anyway,